Ladies and gentlemen, it's my privilege and pleasure to be closing the 8th CPDP conference. My esteemed predecessor as European Data Protection Supervisor, Peter Hastings, very well known, was a fervent advocate of this event. Please be assured that I will maintain this advocacy. Although I have not been able to personally attend as many sessions as I would have liked, including the last one, I've been receiving regular and comprehensive intel from my network of informers on the ground, a sort of institutional German Stasi, but I will not call them EDPS bots. Hashtags EU Data P continues to trend vigorously. There are now, of course, many conferences on privacy, but let me say it is the CPDP which remains the epicenter for creative ideas, sharp analysis, fierce debate on privacy and data protection. Paul, in 8 years, you have built a great international democratic coffee shop, a place where bright young scholars and campaigners can rub shoulders with battle-hardened regulators, where inquisitive techies can brush up against canny corporate lawyers. This week, you have been tackling the biggest issues in the forensic details, from location tracking to transatlantic dialogue, from copyright to competition. Let me just touch on few of these themes. First, last year's rulings from the Court of Justice have been the focus of many interesting discussions in several sessions. For instance, panelists have explained how the data retention ruling has given law enforcement and security authorities a clear set of criteria which they must respect when they derogate from the fundamental rights to privacy and data protection. And second, the ruling in the Google Spain case clarified the territorial scope of application of the EU data protection law in respect of search engines. And let me say that there is a growing expectation that the right to be forgotten should apply to .com domains as well. The conference has assessed the damage to trust after Snowden revelations and its impact on both individuals and industry. 18 months since the first revelations, allegations, there has been much talk but little action. We learn about the many engineering solutions, initiatives for enhancing data protection and privacy, including IPEN. And clearly there are many opportunities for fruitful cooperation on the technological changes. Finally, there have been many exchanges of views on the international transatlantic dimension of data protection. And with the transatlantic dialogue, we have looked at ways of improving how we engage and we seek greater convergence. Some panelists have also suggested adding to the EU-US trade negotiations a sort of a permanent negotiation platform on privacy and data protection. So efforts should be continued in developing global privacy rules. And overall, many rich discussions, a lot of substance. So once again, Paul Dehert, Professor Paul Dehert, congratulations to you and your remarkable team of organizers for such a superb conference. Let me say a few words more on the general context before approaching other conclusive remarks in terms of vision. 2 weeks ago, Europe marched the streets of Paris in solidarity for our fundamental rights and freedoms. There is no better time than now than today to remember that we cannot have security without privacy, that excessive surveillance has the effect of chilling rather than preserving our privacy and data protection. This is truly an historic moment for data protection. The way we respond now to rapid change and challenges, including threats to security, will have ramifications not just for us, but also for the next generations, which is growing up to online today. I mean, the challenges and changes of how people communicate, consume, and contribute to the political life, how businesses set themselves up to make profits, how governments interpret their duty to protect, and how engineers design and develop technologies. The scale of data processing today, made possible through cloud computing services, big data analytics, and electronic surveillance techniques, is unprecedented. And therefore, Europe needs to be at the forefront in shaping a global digital standard for privacy and data protection, a standard which is centered on the rights of individuals. Allow me to say what my goal is as the new European Data Protection Supervisor, and to briefly sketch out what my institution will do to address the big issues which you have been discussing this week. My goal is for the European Union to speak with one voice on data protection. One voice which is to be credible, informed, and relevant. And I want the EU to lead by example as a beacon of respect for digital rights. My colleague Wojciech Wieworowski and I are clear about our priority over the next 5 years. We will seek to enforce and reinforce EU privacy and data protection standards, both in practice and in law. In our viewpoint, EU institutions must be beyond reproach in how they handle personal information and in how they devise policies and laws which involve handling personal information. And we will actively promote a new data protection culture in the EU through equipping policymakers with toolkits, for instance, for developing innovative legal and technical solutions. And with the DPS uniquely EU perspective, we will facilitate greater cooperation on issues that go across borders. So exemplary leadership and active leadership partnership will be our watchwords. But what about the strategy to follow, to implement this vision? In a few weeks, I will present a strategic plan on what we will do to help turn this vision into reality. I would only at this stage highlight 3 particular areas where we intend to focus our energies and expertise in the next few years. On top of them, we have the European Union data protection reform. We are working on a clear, modern, future-oriented set of rules which remains key to solving Europe's digital challenge. The EU has had over 3 years to talk about this, but society and technology will not wait for Europe to get its act together. The ongoing legal uncertainty is damaging for citizens and businesses, and this is why on Monday next week I will be urging the Council to speed up the process. My colleague and I will be more active in seeking workable solutions that avoid red tape, that are flexible for technological innovation and cross-border data flows. So that we have a clear set of criteria which law enforcement and national security must respect, again, when they derogate from fundamental rights. I make no promises on specifics, but let me say, be prepared late spring to be surprised. Secondly, data protection must go digital, and there is no doubt that technology brings many social benefits, but no technology is neutral, and no technology should be allowed to dictate society's ethical considerations. Feasible does not mean morally tenable. So big data entails big accountability and real accountability, which is not mere compliance with the letter of the law. We need of a new deal on data protection, a new deal on transparency, not hiding behind misleading privacy policies, transparency about who is responsible and for what, transparency about why they are doing certain processing of personal data, about how long they will keep it and with whom they intend to share the information. Big data protection should give individuals up-to-date and meaningful rights of access and information about data processing. A right now about algorithms, which create correlations and assumptions about them. How personal information are combined into predictions. Why? Because these assumptions allow others to lead to unfair discrimination. 19th century policymakers ignored the environmental consequences of widespread industrialization. And in the headlong rush for digital innovation, we must not repeat such errors at the expense of our fundamental rights. We want, therefore, a better informed European-wide conversation on what big data and the Internet of Things will mean for our digital rights. But these, of course, are global concerns, not merely European issues. And so, thirdly, I would like to build a new global partnership to clear common grounds on principles which inform not only binding laws, but also the design of businesses, operation, and technologies. Data protection laws are national, but data are not. This is why we would like to invest in better dialogue with regulators, industry, civil society, to explore how to make international cooperation, particularly transatlantic agreements, more balanced in practice. You may say, at the end, what is different compared to the past? Well, you should expect to see data protection mainstreamed across the broadest sweep of EU policies. Data protection as a top policy priority and as a top political priority. So what we have to do is to identify solutions and therefore to consider individuals not as objects of mass surveillance and suspicion. I think this is one of the biggest lessons we have learned from the European Court of Justice judgment on data retention. And you should expect us at the DPS to foster an ethical dimension to data protection through a dialogue between experts in the field of human rights and technology. And you should expect much greater cooperation at international level, including certain new areas concerning terrorism and surveillance. Let me go really to the conclusion, ladies and gentlemen, to say the EU is at its best when it leads by example. When citizens and our international partners can see that our actions are consistent, fully consistent with what we profess to be our values. And from what we have seen this week at the CPDP, I'm more convinced than ever that Europe can now show that leadership on the biggest questions concerning the right of individuals. You can count on the newly appointed European Data Protection Supervisor and Assistant Supervisor to provide not only an expert, but also a very passionate commitment to this cause. And therefore, my final message is see you at the CPDP 2016. I hope the title will be, after data protection on the move, data protection on the ground. Perhaps it's now time to go back to work, but I'm sure Paul would like to close the dances and invite us to a wonderful drink. Thank you for your attention.